Good morning and welcome to the First District Court of Appeal. We have two cases on our oral argument calendar this morning. We'll take them in the order that they were published. The first case is case number 24-2227. Frency Moore and Yuri Ramos as personal representatives of the estate of Celia Lario versus Billy Ray Bowman et al. Appellant's counsel?
Yes, Your Honor.
If you're ready.
Thank you. I'll have 3 minutes for rebuttal, please.
You said 3?
Yes, Your Honor.
Thank you. Noted.
Good morning. Your Honor, we have the pleasure of representing Ms. Lario. Obviously, this is a dram shop case, Your Honors, and our position, obviously, is that a reasonable juror could find that Mr. Bowman, the drunk driver in this case, was a habitual addict. We start with the fact that the bartender, one of them was an elementary school friend of his. That's record 2281. The other bartender was a girlfriend. One of the other bartenders was his girlfriend. That's record 1721. Before he walks in the bar that night, we also have evidence that he had blacked out drunk in 2019. That's record 155.
Well, counsel,
yes.
Before we get into the specific points of fact that you believe supports your position, I want a little bigger picture on the Dram Shop Act. My first observation when I see this is that the Supreme Court has said a number of times that Section 768(1)25 does not create a cause of action. What it does is it simply opens the door to a different cause of action, negligence cause of action, a wrongful death cause of action. Generally, the door is closed, right? It's an immunity statute, but there are exceptions that allow suit. So if 768(1)25 does not create a cause of action, which is very clear from the Supreme Court, how is it that the cause of action is specifically driven by what the statute says and what the statute requires?
Because common law, there existed negligence actions, right? And then the statute says you can't sue these bar owners for policy reasons except in these circumstances. So then you have to craft your case around those limitations set out in the Dram Shop statute.
Right, but the cause of action is a negligence cause of action.
That's correct.
So it seems to me that this is really a legal question for the court to determine whether the defendant is immune from suit at all.
That's right.
And if that's true, why do we even apply the summary judgment standard? If it's not going to go to the jury, if the jury is not responsible for determining whether your client was habitually addicted to alcohol, why does summary judgment even apply to this? The jury isn't there to find whether your client is habitually addicted to alcohol because this isn't a cause of action. The cause of action is negligence. So why is summary judgment even the right tool to raise this claim?
That's a good question, Your Honor. The habitual addict part of this is a legal determination. I agree with you. We feel that the court respectfully made the wrong decision on whether or not there was a question of fact on that issue. And I think what Your Honor is saying is that's not a question of fact, it's a question of law. Therefore, why are we talking about this? And right. I don't disagree with you. I think this is a new or should have known standard. Like all other negligence cases, and this court is well aware of the Faircloth decision where y'all dealt with the other part of the Dram Shop statute and basically said, yes, comparative negligence does apply. So these principles that you're talking about do apply to the ultimate negligence case that would exist before the jury. Did the bar act as a reasonable and prudent bar in carrying out its procedures to determine whether or not this person should have been served or not? So I agree with that.
So it seems to me that there is a plethora of evidence that Mr. Bowman had way too much to drink that night. That is not in dispute at all. But what you have to show is the bar knowingly served a person habitually addicted to the use of alcohol. So a pattern, I think the Supreme Court called it in one place, a class of persons who lack the ability to make a responsible decision in the consumption of alcohol. So clearly, he made irresponsible decisions that night. But what evidence is there that he belongs to a class of persons who lack the ability to make responsible decisions?
Your Honor, I was going through that list. We've got a 2019 blackout, drunk, 155. That's a year or two before this. Counseling for alcohol issues, that's record, let's see. Counseling with Dr. Shi Maria, that's record 657. That's in 2019 and 2020. Also referenced at 2286. The bar knew, before he walked in the bar that night, they knew him. He's part of the service industry in that little town. This is Orange Beach, Perdido Key. Y'all know what this is. And so we've got a service industry night. This is called SIN night, Service Industry Night. And that's where they give discounts to all the people that work in other restaurants and bars. Mr. Bowman was a member of that service industry community, and that's at 1048 in the record, Your Honor. It's a small town, that's at 1046 in the record. The bar's not busy, that's at 1253. Social media, as your honors are well aware, when you publish things about your drinking habits on social media before this happens, that gives the bar notice that you have a drinking problem, especially when the bartenders are friends with you on social media. So if I'm answering your question, that's at 741 and 2283 in the record. The social media posts that you yourself publish to the world and you say that your only drinking problem is when you run out, that's at 2298 and 498. That night, before he walked in the bar, we also had a report from another driver that told the extra duty police force that was working at the door, the person in that red Jeep was driving like a person that was drunk. And the deputy said, he went and told the deputies at the front door of the Floribama that person had been driving erratically. That's at 1914 and 1919 in the record, and 1956 and 1958 of the record.
So what I'm hearing from you is that his actions are somewhat episodic. And I guess I'm wondering, under the standard that Judge Roberts just read, I think from the Ellis Supreme Court case, this idea of the ability or lacking the ability to make responsible decisions, can that be episodic? I mean, can it be, I'm very responsible with my alcohol Monday to Thursday, but on weekends, I'm all over the place. You know, does my control Monday through Thursday obviate this rule, or can it be episodic? Or can it be just on the big holidays? You know, I get blowout drunk and I'm driving all over town. That's just the way I do it. The rest of the year, good. How do we deal with that?
Judge, the statute doesn't say alcoholic. Alcoholic is a diagnosis that sort of pervades you forever. That's something that you can't get away from. The statute says habitually addicted. In other words, you have a habit and routine of when you drink, you can't stop. When you drink, you have trouble saying no. And so to answer your question directly, I think it can be episodic. And obviously these social drinkers can also have a problem regulating how much they drink when they drink.
So is there any evidence of the record of Mr. Bowman going to a place and having a couple of beers and going home, like, you know, responsible drinking?
Yes, Your Honor.
So there's evidence of that?
Yes, Your Honor. There's plenty of people.
So he's not one of these people that, you know, if he has one drink, he's going to have 20.
I don't think that's what this case shows.
He had way too much this night, right?
Yes, way too much this night. We have, there's video, 4 drinks in 23 minutes. And there's a question of fact of whether those are doubles or singles. 4 drinks in 23 minutes. So, and to answer your question.
Well, that's why I'm trying to narrow in on the habitually addicted part. Because, you know, if we were in a state that had a regular dram shop law,
right,
this would be a great case for you. It would be easy peasy. But we don't have a regular dram shop law.
3 feet away from this office, Your Honor, in Alabama. Yes, correct.
Right.
This is on the state line, right?
Yeah. So, and that's why you have a very much tougher case.
That is correct.
You have to show he's habitually addicted.
That's correct.
And you just said there's evidence in the record that he is able to drink responsibly, but on this night he didn't.
That's correct. And I didn't say that it was my opinion that he was. The question was, is there evidence in the record that he did drink responsibly? The honest answer to that question is yes, there is evidence in the record. But it comes from people that are his family, The two people that were in the car with him that night, they were also drunk and got kicked out of the bar. So the sentencing judge, Judge Simon, looked at this defendant, and this is in the record too, and said, I don't think you're being honest about how much you drank that night, to this court. And so to answer your question, the record does have evidence that he drank responsibly on occasion, but it also has record that that night he was showing an intemperance to being able to control his drinking habits. And isn't that what these courts are for? To determine whether or not there's a question of fact on these issues. And so it's...
And there's something habitual about the fact that on that night he had drunk too much, right? It's habitually addicted or a habitual drunkard, I think the Ellis case talks about.
Right.
So there has to be something habitual about that kind of activity, even if maybe what you're saying is even if there's evidence that he can also at times drink socially one or two and be done, there's also this other evidence. Is that what I'm getting from you?
Your Honor, I think the counseling in 2 years before this for being blackout drunk, that didn't follow everybody around in their life. Not everybody has counseling for alcohol, drug addiction, where you get blackout drunk and you have to seek counseling. That happened before this.
So what was the nature of that counseling? Did an employer send him to the counseling, or was it a court? What happened?
I don't believe it was court ordered. I believe, frankly, I don't know. I'm sorry. But it was a licensed mental health counselor, licensed mental health counselor, She Maria, has in her records, and again, I pointed out to Your Honor, that was at pages 2286 of the record. And it related to an episode where he had some issues with his family, I believe, Your Honor. And if I'm not mistaken, grandfather passed away somewhat recently to that time, and he went through a period of time where he was binge drinking, I guess they called it, and he blacked out drunk at least once. So that is something that obviously is in the record that shows that this is not like a one-time thing. And I feel like the dram shop statute in Florida was actually created from a policy standpoint. We're the state of tourism, right? And okay, you can't have bars having these people from out of state come in one time, get drunk, and get sued. That's not going to work here, right? But this is not that person. This is a person that actually lives in the local community, frequents the bar. The bartender knows his drink of choice. Let's see where that is. Record. 1048. And so it looks like I got yellow. So I'm going to stop and save my time for rebuttal unless Your Honor has a question. Thank you.
Thank you.
Thank you.
Thank you. May it please the Court. So as Your Honor mentioned a moment ago, we were concerning what's the real meaning of 768.125 and what does it mean, okay? And what that is, as Your Honor so stated, is a shield statute. And it is referring to, what it does is it protects sellers of alcohol, who's a legitimate business, from liability based off of what their patrons do once they've drank alcohol. And it represents a policy decision by which we are going to blame the drinker of the alcohol for...
So isn't the knowledge of all the agents of a principal imputed to that principal?
Yes, Your Honor.
All these employees that knew Mr. Bowman, the stuff that they knew about him, isn't that imputed to the Floribama?
Well, yes, Your Honor, but the issue is what did they know, and what they know is that he's not a habitual drunkard. We continue to act as if that is not a important issue. Knowledge of someone being a habitual drunkard requires them to meet the definition of habitual drunkard, and if all of the bartenders know him and know he's not a habitual drunkard, that doesn't convey knowledge to the organization that he is one. right?
But
Because
that's
we're,
sort of a fact, that's a fact issue, right? That's a credibility call as to the witnesses and a fact issue.
well, it is a fact issue to the extent, but we have to have countervailing evidence. It's not like the court is weighing, oh, I have 5 witnesses that say he's a habitual drunkard, or is not a habitual drunkard. He doesn't drink excessively. He doesn't have an addiction to alcohol where he can't stop drinking. I have 5 witnesses say that, but we don't have any evidence that says he is one. Right, we're attacking this as if if there's an issue of weight or credibility or something else like that. But there's actually no evidence whatsoever that he is a habitual drunkard. His friends say he's not. Right, the fact that we mentioned
How about
once,
the counseling and the blackout situation and,
Well,
and that other evidence that maybe leans the other way?
well, as the trial court found in its order, is that that's not evidence of someone being a habitual drunkard. If someone is drunk once in 2019 and gets blackout drunk and doesn't drink again, that's a sign that they're not one. Or they decrease their drinking. And this is not, we're characterizing this as if he's seeking counseling for alcohol. He's not. He's seeking counseling generally, and as part of that counseling, he mentioned that when his grandpa died, he drank too much. Okay, and part of the counseling is that he agreed that he's to slow down his drinking because it wasn't healthy for him, and he did that. And so that's the opposite of how plaintiff is producing this. Because if you had an issue where you have a one-time situation where your grandfather dies and you get blackout drunk once and then you don't get blackout drunk for the next few years, that's a sign you're not a habitual drunkard.
How about if it's once a year, every New Year's Eve, I'm gonna get drunk and I'm gonna drive around. That's what I do.
Well, that shows control, because it shows you're able to control until that once a year. If you have blackout drunk every Friday night, it shows you have control, right? Because this statute, it says, let me rephrase this. The Ellis
So
Court,
controlling yourself Monday to Wednesday is enough control that you can blow it out every weekend and drive around, and that's not.
I think yes, because the issue is the way that Ellis phrases what a habitual drunkard is. It's not someone who has an alcohol problem. It's not someone that drinks too much. It's not. The problem is someone who has not. The exact phrase is a class of persons who lack the ability to make responsible decisions in the consumption of alcohol. Not that they drink a whole lot when they choose to drink. It's just they can't make that decision. It's a mens rea issue. What we're saying is we're not going to blame the tavern for the consumption of alcohol. We're going to blame them only if they know that they don't have the capacity to make that decision. So essentially, is the tavern's making that decision for them. And that's the only time that we're ever going to have liability here. And we can't, in every case where there's where a tragedy has happened, we can't go through and just pick apart, one time 3 years ago he drank too much. One time he told his friend that, alcohol wasn't a good thing to have. Or one time he made a bad joke on a Facebook profile that, his only problem is when he runs out of alcohol. When we pick apart these things, that's not evidence of someone being a habitual drunkard. It's not evidence that can be weighed at all, let alone by a jury. That sort of analysis is exactly the kind of effort and work that they're trying to avoid by having this shield statute.
So how much weight should we give to the sober drunkard theory? Because at least Mr. Bowman's on film, they don't have hard evidence of what he had before he got to the Florida Bama bar, but he had 6 drinks in about 50 minutes at the Florida Bama bar, and it's on video, right? And he appeared to be completely sober after those 6 drinks, even if they were singles.
Well,
and his buddies were so drunk they got thrown out of the bar.
Yeah, they'd been thrown out.
In the same amount of time. So wouldn't their argument is a bartender should know someone that can drink that much and appear to be sober is a habitual alcohol abuser? Well,
I want to say, first of all, this is I don't think it's good law anymore, but I want to go kind of a little bit more basic. And I want to state that what that test does is determine whether there's a triable issue under the old summary judgment standard, when there's like a scintilla of evidence, that allows them to go to trial on the issue of knowledge. It does not establish that he is one, right? Because if he is unable to control his alcohol every day, no matter, if he's unable to control his alcohol consumption, we're going to have evidence that that's the case. And the roster court, which is the sober drunkard test came from, that was already established that he was a habitual drunkard. So it's only a question of whether we can get a little hint, whether there's a hint of knowledge that can be taken by the jury to establish knowledge of that fact. But we're completely ignoring the fact that there's no evidence that he is a habitual drunkard in this situation. So in
How
other
about
words,
the social media post or the joke, to the extent of the only alcohol problem I have is when I don't have any alcohol?
yeah, it was supposed to be from a song lyric, apparently, based off of so it's not like he's telling the world, I love alcohol and I can't stop drinking it or something.
That's what it seems like that would.
Well, that's
I
an
can take
implication, but we
So in
ha-
your view, this statute would only allow Otis from the Andy Griffith Show to be sued? Just Otis, do you know who I'm talking about?
I'm sorry, I did not actually catch what you
Okay.
said. My apologies.
It's an old show where there was a town drunk and everybody knew he was the town drunk. And-
Okay. Well,
Yeah.
well, I mean, essentially, the idea is we don't want to have a tavern that's just, got somebody that's just, willing just to throw all their money out every night. Like, sure, we'll take your money and let you drunk every night. If someone shows up on occasion and sometimes drinks, heavily, that's not, habitual drunkard, under the statute. And so, what we're doing here is we're splicing together evidence of someone who, piecing every little piece of their life to try and establish any sort of alcohol use. But the reality is the fact is that there's an absence of it, right? If we have 5 witnesses that are saying that he doesn't do this, where are the 5 witnesses, or the millions that there should be, or any one at least, that's saying that he does have this problem? It just doesn't exist. And, this statute, the Shield statute, does not work if we can't, knock out cases like this before we go to a jury. Because a jury is going to be, someone died, it's terrible. And there's someone that did something terrible. They drove after drinking have too much. They drove after drinking irresponsibly, and they killed someone. It's terrible. And a jury is going to hear this, and they're going to be very sympathetic. And I don't know how that's going to turn out. And if this goes to trial in that way, we're going to have a situation where there's no evidence at all to support the plaintiff's claim, but we're piecing it together to make it kind of sound like, this person is a drunkard. And this sober drunkard theory, I'm sorry, let me get back to that. This idea behind it, of course.
So the judiciary should not really trust the jurors to apply statutes that we instruct them on?
Well, of course, we do trust the jury to come to these conclusions, but when you have an issue of law that's very specific, that we don't have to risk that sort of mistake being made, it's better to do so. From the perspective, because the reality is there's no evidence to indicate that this person was a habitual drunkard, that they could not control their alcohol consumption, as we just heard. That's the case. Now, and to emphasize about the sober drunkard, the only evidence apparently might be the sober drunkard theory that we have, and there's just so many problems with that. Obviously beyond just the knowledge issue. First is that the video that we talked about, as the trial court found, does not actually show 6 double pours. You can't even see the pours being made. It just doesn't show it. And we're presuming that they're double pours for some reason. And we're presuming it based off of that the manufacturer's website said that up to 1 ounce can come out every second. Up to, not it does. And not it does
Well,
every
even if they're
circumstance.
single, 6 highballs in an hour is a lot of booze, right?
Well, hypothetically, 6 drinks, yeah, absolutely. We're not questioning he's drank too much. If the idea is that, should he, morally or appropriately not have drank that much, of course not. But the issue is that, they're not double drinks. He didn't drink all of the drinks. The observations about sobriety, of course, there are some about sobriety, but even Preston Rideout, in his deposition testimony, who is the expert, stated that he did look drunk. The people that were there just didn't notice him, okay? So, and they just didn't testify to it. So, there just isn't evidence that he is a habitual drunkard, and it just doesn't exist.
Counsel, let me ask you, shift back to the definition from Ellis of the statutory language. This is a little tough to nail down, habitually addicted to alcohol. But both of you have used the standard from Ellis, which is a class of persons who lacks the ability to make a responsible decision in the consumption of alcohol. But there's this case from earlier that used the phrase habitual intemperance, which is completely different. It's from an old, I think, a divorce case. And I did see that phrase used and the language from that case used in the order. Did the court apply the correct standard? And is the correct standard the standard from Ellis?
That's
and if
right.
so, when they mentioned habitual intemperance from this other case, this Sabo case, did the judge apply the wrong standard in determining when someone is habitually addicted to alcohol?
Well, the court explicitly stated it used the Ellis standard and didn't cite to, I believe it's a Cabo, or is that the case?
Sabo, I'm pretty sure.
Sabo,
Pretty
sorry.
sure he did.
It didn't even cite to Sabo. And so now it's possible there's a reference to it, but it didn't base the decision off of it. It based it off of Ellis. So, I mean, perhaps it had the word intemperance in there, but all the citations are for the Ellis and the Ellis standard. And I don't really understand what the distinction is supposed to be, because I don't believe that was an argument that was brought, in terms of habitual intemperance, or, how that would be any different. I'm not really sure what issue my opposing counsel is bringing up when he suggests that the court was using that standard, because it seems pretty clear to me that it used Ellis. And it's, progeny. Now, they might have had reference to it, several case law discussing, concepts related to it, but they're not, the court was clear on how it made its decision. And I do want to also emphasize, about the only thing that we have here is that, that sober drunkard test. Further, the court found that there was, that there wasn't good input because we couldn't see the videos. The methodology was bad because there's no, it was based off of the manufacturer's statement. And it doesn't really make sense as applied to this case, because in this circumstance, for the logic of Roster to apply and the sober drunkard theory, you have to have someone that observes someone drink excessively and then see that they are able, that one person sees that they're able to apparently hold their liquor as if they weren't even drinking, and then they serve them afterwards, right? So we don't even have that here. We have someone who had 5 drinks somewhat quickly and then left. Now, the agency issue that we're talking about here, I do want to get back to that and say, aren't we going to presume that all the people who served him drinks, that information is going to be brought together? And I want to state that that's not really, agency law can allow you to convey something meaningful that happens, but not something, the fact that one person had a drink, that a particular bar patron had a drink, in a whole other room, another bartender saw that that person had a drink in that other bar. It doesn't make sense for us to just presume that disparate information that's not important would be conveyed, to the principal. Of course, we want to have a rule where an agency that we don't, we want to encourage the company to ensure that they have information that they don't want to have to say, well, we didn't know about it because nobody told us about it. But that's not the situation here, because this isn't a relevant piece of information that's coming in. It's information that only becomes important because it's synthesized by 3 different people in real time. And so it's just logically absurd to hold this bar responsible for knowing exactly how many drinks this person had, and exactly, the way he looked, when there's 3 different rooms and multiple bars in each one of those rooms. To hold the tavern responsible based off of just that information, it's sort of a logical absurdity. And let me see here, 37 seconds. I just want to also emphasize that the expert affidavits here, there's no information that they conveyed. All they took is information that they did not drink, and then later characterized that. And so it's inappropriate.
You may briefly conclude.
Thank you so much.
Thank you.
I honestly, that was pretty much my concluding point. Thank you.
Thank you, Ms. Huber.
The Facebook post, I'm sorry, the Instagram post was 2 years before the song came out, to start with. So we've got a guy holding Devil's Cut Jim Beam with a glass, no mixers, warm liquor, drinking it straight from the glass in 2015, before this song came out that has the lyrics that they're suggesting. So then we've got a guy that's drinking on the beach warm gin with his buddies. No mixers. Then shows up at the floor, Bama, and drinks, as Judge Roberts pointed out, 6 drinks in less than 50 minutes.
Counsel, I want you to address something that the trial court said that I'll read to you. It's about the fact that he may not have appeared drunk at the bar. The judge wrote, the observation that a patron doesn't appear intoxicated after drinking will necessarily occur after the patron was served. Accordingly, the wrongful service of alcoholic beverages could only occur at some point in time after the patron had already consumed an extraordinary amount of alcohol and sufficient time had passed for the patron to appear more sober than he should be. What's your response to that contention by the trial judge?
I think that's half accurate. I mean, I think that, yes, if you just have 3 drinks in an hour, maybe you should have to wait the whole hour to determine whether or not the person has the effect of alcohol. But we've got a guy that had 3 drinks in 20 minutes. And we contend, and we feel like there's evidence, is there are 3 doubles.
So at what point should they not serve him because he is apparently an habitual drunkard, habitually addicted?
I would suggest it would be 1 drink an hour, and if you're doing more than 1 drink an hour, there should be some red flags that go up on your staff's part. If you drink 3 drinks in 24 minutes, somebody should be sounding alarms about that person.
So habitually addicted doesn't have to mean, what you've suggested in other evidence, that he walked in the bar, they know that guy is habitually addicted to alcohol, but that it can just sort of create over time simply by his drinking and his reaction to it. You can make the conclusion at that point?
Your Honor, I think that a responsible bar should train their bartenders for that reason. Yes, Your Honor. I think that that's one way to get to the habitual addict status, is that way. The other way is to have all this circumstantial evidence that we do have in this case. She said that
Isn't there a lot more variables? I mean, I don't know how big a guy Mr. Bowman is, but I mean, if the guy weighs 120 pounds, the alcohol is going to hit him a lot quicker and have more effect than if the guy weighs 260. And if the person is drinking on an empty stomach, it's going to be different when if they just had a big meal, right?
I think that's true, Your Honor. But when you're training bar staff, I think you use generalities for the average person. And in this case, obviously, they said there's no evidence that he had a habitual addiction to alcohol. So we obviously disagree with that.
Thank you.
Thank you, Your Honor.